Welcome to What You Really Want to Know. This is a special edition with notable approval. Before I get into that, first want to remind you to make sure you like us and follow us on Facebook and wherever we are, YouTube and Instagram, so you don't miss this or any other of our lives. So today, it's a little different than our normal notable approvals where I just talk about a case that we recently got approved. That part is the same, but this case presented something very interesting and annoying, dealing with requests for evidence or RFEs. And we get a lot of questions about RFEs, a lot of clients who, or potential clients who call us and hire us to do the RFEs. So there's a few things that I wanted to talk about that this case highlights that's very important. So I'll talk about all of that. And I decided to do this morning, so I didn't post this. Hey Lambert, thank you for watching. I didn't post. You're always here no matter when I post it, but I didn't post this too far in advance. So if you do have questions, please ask. If you see this afterwards on replay and you have questions, again, contact information going across the bottom of your screen. Please do not hesitate to reach out. So this case is about a client who is a native and citizen of Canada. He had been here on a TN visa he had been here for like 6 years or something. Over the summer, he was told that he no longer was going to have a job in 2 weeks. And at that point, basically he had a choice. He does get a 60-day grace period on a TN. Oh, I'm sorry. Give me 1 second, guys. I couldn't see my comments. Hi, Kareen. Thank you for watching. So he, I lost my train of thought. He had to decide if he was going to leave within 60 days or change status or what he was going to do. Now, TN visas, first of all, can be a little tricky when it comes to extending your status, changing your status. Hey, Chris. Nice to see you. There's no C in my last name, but no worries. So basically, with the TN visa, it's a non-immigrant visa, meaning you're telling the U.S. government every time you apply that you're not going to remain in the U.S. permanently. However, unlike an H-1B visa, there is no limit to how many renewals you can have. So with an H-1B, with some exceptions, you can only be on an H-1B for 6 years. With a TN, I think they're valid for either 2 or 3 years, depending, and you can renew it. There's no limit to that, but you still have to prove I'm not staying in the U.S. permanently. And that's really what the tricky part is when you talk about subsequent renewals. And we'll get to that in a second. I also want to point out, I will tell Jessica and Aaron that you say hi. We have a question from Abdel Manim. I'm sorry if I mispronounced her name. When a law says 18 years or younger, a person who's 18 years plus couple of months. This is our question here. I don't know what you're asking about eligibility for, but if you re-ask the question, I may be able to answer it. So the grace period for a TN visa, that's important. What is a grace period? That is the time between when you stop working or you lose your job and the time that you have to leave the country. Now, if you lose your job on a TN, you're terminated, you get 60 days. But if you work until the end of that 3-year period with your TN visa, you only get 10 days. Now, each non-immigrant visa category is a little different. So if you're here on a different non-immigrant visa, work visa, do not assume you get the same grace period. You should check with an experienced immigration attorney, and I'd be happy to help you with that. So he did have 60 days to figure out what he was going to do. Now, the problem for him is he owns a house in the U.S. So although he fully intended to leave the country, he first had to fix up his house and sell it, because I believe he had like another year left on the TN visa before he'd have to renew it and make any decisions. So he started looking for jobs in Canada. He figured, all right, I'll take a few months off, fix up the house. He has a pool that needed some work. I'll get that all done and I'll sell the house. He did look into going back to Canada, re-entering on a B2 visa. Of course, from Canada, you can also enter on a visa waiver, but somebody who's been here for a while on a TN could have a problem with a visa waiver. So B2 may be the way to go. So he could have came back, did what he needed, and then gone back. But the problem was the pandemic. So the border was closed. Although he could have gotten back to Canada, he wouldn't have been able to get back to the US, where he needed to be to fix up his house and sell his house. It was just impossible for him to do it remotely. So within that 60-day period, between the last day that he was at his job until the 60 days were up, he filed for a change of status to a B2. And he did that before he hired us. So that's pending. And he starts to do what he told immigration he was going to do. Starts fixing up his house. He starts looking for jobs in Canada. He's an electrical engineer. He could not find any jobs in Canada. This was, again, over the summer, pandemic's going strong. So he says, all right, I got to expand my search, starts looking for some jobs in the US. And in December, he gets an offer. And while this is all going on, other than getting his receipt notice and biometrics notice from USCIS, he's not heard anything from them. They've not asked him for anything, nothing. So, and he had asked for 6 months on the B2 from the date that he was going to have to leave the country. So he comes to us and we say, okay, no problem. We're in that 6-month period. We can file for a change of status back to a TN. And we did that with premium processing. So I've done this many times before, where literally with the same exact scenario where I had someone on a TN change their status to a B2, and while the B2 is still pending, change their status back to a TN because they got another job offer. Completely normal. I've done it plenty of times. Again, you have to show your non-immigrant intent. So that means your ties back to your country, but certainly doable. So we do a premium processing, which means within 15 days, either USCIS has to send a request for evidence or make a decision. So it's about day 13 or something, and we get a request for evidence. And it was a frustrating request for evidence because it asked for 3 things, all of which we sent them evidence on. It asked them for evidence of his professional level activities, business activities. Basically, they're like, what's his profession? What's his NAFTA profession? Because for a TN, there are these regulations in NAFTA, and you have to be one of those stated professions. There's a long list. That was frustrating because we said he's an engineer, and we described his job duties as an engineer. And we gave them, what did we give them? A job offer letter from the company saying, this is the type of company that we are. We're hiring you as an electrical engineer. These are your job duties. These are your qualifications for the job. Great. Then we also gave them his resume, engineer license, and his engineering diploma, which I've done. Like I said, I've done these before. Never had a problem with that type of evidence. Certain jobs are harder to show than others. Like if someone comes to me and says, I want to do consulting. Well, then you have to start framing where that's going to be in the NAFTA regulations. But engineer is literally one of the stated professions, so it shouldn't have been any issue. Then they wanted, evidence of maintenance of status and B2 approval. Well, we of course submitted evidence of maintenance of status. We showed them his last paycheck. We showed them the job termination letter. We sent them the I-94. We sent them the non-immigrant visa stamp or the TN stamp. I think it was a stamp. Either that or it was a stamp. And we sent them the receipt notice for the B2. And we had already explained both in our cover letter, which cover letters aren't evidence, but it's there. And then in his statement, and then we gave them the receipt notice for the I-539 change of status application. And so we explained to them, look, there's been no decision yet. This is not, you know, he can't do anything about it. We've not heard anything. And we even printed out to show them on the case status inquiry, like it's still pending as of today, as of when we're sending this to you. So we had sent them all of that. And then they also wanted evidence of his non-immigrant intent. Now, again, he had sent that with his I-539 explaining what he was doing with the pool and everything in the house. We explained that in his letter, and we submitted some of that evidence. So the first thing I want to point out before I talk about how we responded and then what happened is it is unfortunately common that you get a request for evidence for something you've already submitted. Even if they only asked for things that we already submitted. And technically, this was one of those RFEs. I mean, sometimes you can submit more evidence. Sometimes you've exhausted all the evidence you could possibly submit. This was a case where we definitely submitted more than as much as I've submitted in other cases where we didn't get a request for evidence. So, but just because you've already submitted it doesn't mean you can ignore the request for evidence. One of the best practices that you can do is you send them, depending on how much evidence we're talking, because I mean, especially this was a fax as opposed to a mailing because of premium processing, but I always reference all the initial evidence we've sent. If it's not too much, I will send in copies, say, hey, look, I sent this to you. Because sometimes they list, you know, this is what you submitted. Sometimes it includes everything and they still say you didn't. Sometimes they leave stuff off and say you didn't. So no matter what, we say, look, this is all the evidence that met your requirements. And we always try to send the application initially with all of the evidence required to prevent these RFEs. But you can't prevent them 100%. It's just impossible. And it's frustrating because we spend extra time to be able to do this. That's beside the point. So point is, we still have to respond. If you ignore it, it does say, if you read it, it will say in there, if you do not respond or you do not respond with all of the evidence requested, we will make a decision based on what we have. Guess what? They're going to deny it. So you either have to send them everything requested or explain why you don't have certain things or why something doesn't apply to you, or tell them you've already given it to them and ideally give them a copy of what you already gave them. So the way we responded to this thing was I had the employer actually go through the job duties, break it down into percentages of time that he'd spend on each. And the categories that I chose were based on the categories that were in the Occupational Outlook Handbook, which is put out by the Department of Labor and Statistics, Bureau of Labor and Statistics. This is what USCIS references when it does all types of labor certifications and work visas. So, and I gave them a printout of that. I also printed out the Nafta Regulations, and I showed them that his stated profession of engineer was on there. And the OOH job that I printed out was electrical engineer. And then we broke it into those categories and said, okay, I mean, I don't remember his job duties exactly, but it was like testing systems. So let's say 25% of the time he's going to test systems. And then, and that falls under like test and maintain hardware or something like that. So we just give the job letter, in my opinion, was sufficient the way we submitted it. I submitted similar ones without an issue, but when they want more, if you can give them more, give them more. Because you're just taking a chance, you know, that you're going to get a denial. It may be a wrong denial, but some denials you can't even appeal. So it's just not worth it. If you can give them more, give them more. And that's what we did for this. Then for the, what was the second one I said? I said the Nafta regulations already, the maintenance of status. Again, we referenced what we had already sent them. And then they were literally asking for the B2 approval and said that they can't approve it until the B2 is approved, which isn't true. And I wrote in the cover letter, look, you know, here's what we gave you that complies with this requirement. There is nothing in the statute or regulations that say that you're required to have your B2 approved before you can change status to the TN. So yeah, he's eligible. And then for this immigrant, non-immigrant intent, what we did was we basically sent everything we could. We sent stuff regarding his ties to Canada. So he has bank accounts in Canada, retirement accounts, maybe a few other things. And then we also we wanted to show them for his maintenance of status what he had been doing in the US since the summer. And that was exactly what he had said in his B2 application, which was fix up the house. He had some complications with fixing up the house and the pool or something. And so we put in all the invoices and lots of evidence regarding that. And we were real optimistic about it, sent it back in. And because, again, premium processing, USCIS had 15 days to respond. So that's either a decision or a second request for evidence. And I'm like, no way there's a second request for evidence. We submitted so much. So then about a week and a half later, my client gets an email because he had submitted his I-539 online, and he gets an RFE for the I-539. Mind you, the I-539, that was the first change of status to a B2. The time period he had asked them to stay in the US had already passed for that application. And again, this is common because they're so backed up. But they ask in there to prove basically, I think it was what he had, they wanted to see that when he stopped going to work. But he had submitted the stuff. He had only submitted like one paycheck. And I go, if you don't have additional paychecks, if you can't access them, then why don't you show your bank account where you submitted the check? So we did that. He didn't have his 2020 W-2 when he mailed his application over the summer, so we sent that in. And then we sent again the job termination letter. So February 25th, he gets the email. February 20 about the I-539 RFE. February 26th, we get a second RFE on the I-129, basically saying again, you didn't respond to the request for evidence, so you need to prove you responded, send us a copy of the response and or a copy of the B2 approval. Thank you, Abdel. I'm going to call you Abdel so I don't mess up your entire name. I apologize for not knowing how to pronounce it. This was our comment here. So we get the second one, and at this point, we're getting a little frustrated because they literally sent the RFE yesterday, and again, there's no law and no regulation or no regulation that says they can't grant the TN before he responds to some request for evidence that they took 8 months to send out. So I said to him, look, again, yes, I know you sent this stuff. Do you have extra stuff? He had extra stuff. So we're going to send this extra stuff. You're going to reference the other stuff that you already sent, and then you're going to give me a copy of all of that, and then I'm going to send in the other RFE response. So we do exactly that. He sends his back, like I think the 26th, and then the next day I send the other one, premium processing, and I remember, or he sent it on a Friday, I believe that was 26th, and I remember this because I was home and it was either Friday night or Saturday night. I get an email from my client saying the same day he sent the RFE response in, it's already been approved, the I-5, the change to a B2. So now he's in valid B2 status from March 1st to April 1st. And I was like, all right, well, I already sent back the RFE response for the I-129, but I might as well just let them know there's an approval notice because there's 2 separate offices that are making this decision. So if you're wondering, are they talking? Is that why we got one the day after the other? It would seem like they're not talking, then it seemed like they're talking. I don't know if they talk. I mean, it should all be in the computer system, but you can't assume they're talking. That's just the bottom line. So we send back the response to the request for evidence. I like waving on Instagram. Hello, Melanie. So we sent back the request for evidence to the I-129. And then the next day, when I got the approval notice from him for the I-539, I sent that to them too. And then we waited about a week and a half. They like to take their time. And finally, again, they had 15 days. We got the approval for him to change his status back to a TN or to his new TN. So that was a lot of stuff to talk about. 3 requests for evidence within a span of 1 month. Yes, there were 2 applications, but they were essentially asking for the same thing. So what you really need to know about requests for evidence, and why I really wanted to highlight this and not just talk about the case, is that you're going to get requests for evidence sometimes that for things that you've already sent, for things that don't apply to you. Like I've been asked for marriage certificates for clients who have never been married, and we've never said they were married. I've been asked for birth certificates that we've already sent. I've been asked for different versions of birth certificates, even though the version I sent complies with what the Department of State says is acceptable documentation. No matter what it is, number one, first and foremost, always respond. If I had prepared this a little more, I would have had bullet points right now. Number one would be always respond to the RFE, even if it's just, hey guys, I sent this to you, and respond within the time period. Do not file it late. Remember, the day that they receive it is the day, not the day that you mail it, is the day that matters. So I can, if it's due today, March 9th, if I mail it today, March 9th, it's late. It has to be received by March 9th. So always respond. Number two, reference any evidence you've already submitted if they are asking for something you already did submit. And if it's possible, include a copy. We send any application out without, or application package without scanning it. So every page of the application, every piece of evidence that we send to USCIS, we have on the computer. So if they say we didn't send it, I can just go into the computer, reprint it, and say we sent it. Now, if you do this by yourself, you may not, or you've done it, or you may not have known to keep a copy. You should, but if you don't have one, then obviously your only option, if you can't get the evidence again, is to reference it. And then again, it depends how much evidence we're talking. If I've sent them 400 pages that they're telling me I didn't send them, I'm not sending them another 400 pages. I'm just telling them I sent it. And I'm like, I do exhibit lists, so I'll say, look, exhibit A through D from the initial package, that's where it is. Even if you sent it to them already, and what you sent them should be sufficient, if you can get additional evidence to satisfy them, get additional evidence to satisfy them. You can never hurt yourself by putting in more evidence. Never. It's not superfluous. It just further shows your eligibility. So if you've already shown them, oh, I got one bank account in Canada, I still have ties, but you have another bank account and an investment account, and you got a tax refund, and you can get all that within the time period, get all of it. It's definitely worth it to hopefully prevent another RFE or a denial. And lastly, don't get too frustrated. That's my job. If you have an attorney, I yelled into the pillow a few times. I was pretty annoyed with USCIS and honestly felt really bad for my client, who was supposed to have started his job over a month ago. And he was just kind of waiting in limbo, being like, because he couldn't start working on the TN until it was approved. But, this is a government agency, a bureaucracy. Things go wrong. It could go a lot wronger than it had in this case. It's frustrating. They asked us for the same thing, but we handled it. We sent it to them, what they wanted. And I had told them the entire time, I have no doubt this is going to be approved. I know you're eligible. I know that you have your non-immigrant intent, maintenance of status, and the proper job under the Nafta regulations. So this is just a matter of kind of semantics with USCIS, and you're not alone. This is a common thing, unfortunately. And then I guess actually one more really important thing. If you have filed without an attorney and you get a request for evidence, I do recommend hiring an attorney, because ultimately if you don't respond to it correctly, then you're going to get denied, or you're going to lose the money that you paid for the filing fee. You're going to have to refile. That's another filing fee. So you're better off, and all the time. I mean, remember, I mentioned that he filed this application initially in the summer for the B2, and not until this February did we get a request for evidence. So it could take so much time that you're end up going to lose by having to refile. If you can respond to the RFE correctly and sufficiently, then you can avoid all of that and a lot of stress, I'm sure, that goes along with it. So that is all today for what you really want to know. And for notable approvals, our special edition on requests for evidence and changes of status and pending changes of status. If you have any questions, please do not hesitate to reach out. Our information has been rolling across the bottom of your screen. And make sure you like us and follow us on all the social media, Facebook, Instagram, YouTube, LinkedIn, Twitter, so you don't miss any more of our lives. And of course, if you have requests for evidence, do not wait until the day before it's due to contact us or any other attorney. Contact an attorney or respond as soon as you get it, because it can take time to get the documents, can take time to put it together, and it can be really stressful if you're, like I said, it's not the date you send it, it's the date they receive it that matters. And, you know, we went through so much headaches with mail these past few months, where things that you paid for overnight, we paid over $100 to FedEx something, and it did not arrive the next day. So you do not want to take that chance, not when this is so important and there's so much on the line. And I know that's how all of our clients feel when they're applying for any immigration benefit. So thank you all for watching, and we'll be back tomorrow. Hopefully I will have time to do, I got some more good notable approvals to talk about. Hope you'll tune in and have a great night.